special needs planning is planning for any individuals who are in receipt of government benefits that would be jeopardized by receiving inheritance. These could be mental, developmental, or physical disabilities. Proper special needs planning makes it so that assets can be left behind to this disabled individual while also preserving the government benefits that they depend upon. These government benefits might be for their health care, for their housing, for food, or for extra income. Having a supplemental needs trust in place creates a situation where the assets that you leave behind are protected within the trust, guarded by a trustee of your choosing, and used to supplement, not supplant, the government benefits of the individual with need. For some parents with children with disabilities, they've spent their entire life caring for this child. It's important that you make sure that you care for them when you're not around anymore. And that's the importance of creating a supplemental needs trust for the benefit of that child. You want to make sure that they are going to have what they need when you're not here anymore to provide it to them. A supplemental needs trust or special needs trust is a trust created for the benefit of somebody who is on government benefits. That trust can own a home, it can purchase a car, it can invest the assets, and it can be used to enhance the life of that individual who is on government benefits. Very often, someone's government benefits are tied to the educational or housing program that they are living in or attending. And the loss of those government benefits, no matter how much money they're inheriting, could upset their normal routine and lifestyle. You can create one of these special needs trusts either as a freestanding trust where multiple family members can list it as the beneficiary of certain assets in their estate, or you can create it within your own documents. So your own last will and testament or your own trust can state that upon your death, any amount that goes to a specific individual be provided to them in a supplemental needs trust. We also can create supplemental needs trusts as what we call a trigger. So we can say that if upon my death any individual is on any government benefits, then only in that instance would their share go into this type of trust. That's really important planning, especially because we're often unaware of what position our beneficiaries are going to be in at the time that we actually die. And so having this provision within the documents is something we like to put in because we don't know what the future holds. And we want to create as much protection for your beneficiaries into the future as we possibly can. There are two main kinds of special needs trusts, first party and third party. A first party trust is a trust that is created for the benefit of a person and their own money is going into it. This might be money that they already have in their name or money that they are actively earning as time goes on. Money can accumulate in that trust and again be used to supplement that person's government benefits. If you have a person who inherits a sum of money and they did not inherit it in a trust, they may have to create their own trust and move the money into it in order to maintain their government benefits. This is a first party trust. Now the biggest downside of this trust is that upon the death of the individual, there's a payback to the Medicaid program. So to the extent that we can avoid doing a first party trust with proper planning in advance so that the assets go directly into a trust, we like to do so. First party trusts are created generally for those under 65 who are on government benefits. The second type of trust is a third party trust. These are monies that are left behind for an individual in a trust structure. So when I have a last will and testament or I have a trust that leaves assets in a supplemental needs trust for another person who is disabled, then those assets will be in a third party trust, and upon their subsequent death, There will be no payback to the government for any services rendered. The assets will go on to the individuals that I've named as the secondary beneficiaries. When possible, we're always looking to create a situation with a third-party trust so there's more control of the assets into the future. Engaging in special needs planning for a disabled beneficiary must be done with an attorney. There's just too much at stake to try and do this at home. Not only are we concerned about the individual's government benefits, but in certain circumstances, the nature of the individual's disability leads them to be unable to handle the funds or make decisions on their own. Proper special needs planning will make sure that they are protected to the fullest extent.